And so now we have the final session before the next coffee break, and it's with a panel discussion moderated by Marion Stadler-Chan, who is a partner at Clifford Chance. So please welcome to the stage Marion Stadler-Chan, also Ada Schmidt, who is a partner for litigation and dispute resolution, and Lauren Harris, counsel corporate. Thank you.
Thank you very much, and good afternoon, ladies and gentlemen, to the session just before the coffee break. And in the next 30 minutes, and I'm not sure we are going to end earlier, we are going to discuss the corporate sustainability reporting topic, especially how to tackle CSRD and potential greenwashing risks. My name is Marion Stadler, and I'm a partner at Clifford Chance in Luxembourg, and I advise clients on the formation of private funds and have a specific focus also on advising my clients on all questions in relation to responsible investing, be it funds making responsible investments, but also, of course, compliance with certain regulations that are in force. I'm very happy that today I'm joined by two of my colleagues. Just on my left side, our litigation dispute resolution partner, Ada Schmidt, also here in Luxembourg. And on my very left side, Lauren Harris, counsel in our corporate department and currently seconded to our London office. So before I'm going to jump into the topic, I would just like to speak about what is the agenda for today's discussion. So we are going to speak first about CSRD, what's the status in general, and also implementation status into Luxembourg law, and then followed by greenwashing. What does it mean? What are the potential risks? And of course also what needs to be undertaken as measures to protect. And then reporting obligations under CSRD, potential enforcement actions with a focus on Luxembourg and outside of Luxembourg, and then how can CSRD actually serve to mitigate greenwashing risks. As I mentioned earlier, I'm a funds formation lawyer, and I am speaking to clients about the compliance with the Sustainable Finance Disclosure Regulation, SFDR, has already mentioned before. And I can tell you it has been quite a journey since 2021, since the regulation, SFDR, and also taxonomy regulation are in force, not only because investors' demands are increasing, but also because some of the requirements are not necessarily clear. And of course, there's always the risk or the worry by asset managers for potential greenwashing allegations. So now CSRD has been mentioned, is just ahead of us, especially because it is now in force since January 2023 and is just about to be implemented into national law. But what does it mean? And the questions we are getting as legal advisors is, so what does it mean for me as an asset manager outside of the EU, inside of the EU, maybe outside, but also with affiliates inside of the EU, and what is the link between now the fund disclosure obligations versus then CSRD at company level, which may be relevant if a fund acquires an entity. So now moving over to you, Lauren, maybe you can just give us an overview on what does it mean, CSRD, what's the scope, and where do we stand in Luxembourg?
Sure. Just to provide a little bit more background with regard to CSRD. So CSRD, I would say it has two main elements or two main focuses. One would be enhancing transparency and sustainability reporting. And then the second would be standardizing ESG disclosures across the EU. And so both of those are actually really important to the other topic, which we're also going to cover, which is greenwashing. So in doing so, with regard to the standardizing of ESG disclosures, there's the harmonization across Europe so that people have a better idea of exactly what to expect, exactly what standards companies are being held to. With regard to the scope and applicability of CSRD, CSRD, it significantly expands the scope of what was previously the NFRD. It extends to large companies, well, to all large companies and all companies which are listed, save for those which would be considered micro companies. And then there's also going to be a staggered rollout with regard to CSRD. And so there's the current intention is that those companies which are currently underneath an FRD will be first applied, and then there will be a staggered rollout furthermore. Then as well, it also is fairly innovative in the fact that it also extends to those companies which are in third countries, let's say, so outside the EU. So companies which are outside the EU, but which have still a nexus to the EU. For example, if they have a particular footprint in the EU, have a branch, et cetera, they also could fall underneath CSRD. And concerning CSRD itself, there is a focus on detailed reporting, on the disclosure of sustainability risks, of ensuring that the reporting information actually follows set standards, and as well following the newly put in place and also further being developed ESRS standards. And concerning Luxembourg, as Baron mentioned, CSRD is in the process of being implemented in Luxembourg. Currently, there's bill number, and let me make sure I get the number right, it's 8370, and it is currently still under discussions. The most recently, there was the opinion of the Conseil d'État in July of this year, and looking forward to hopefully having it implemented soon. So yes, background.
Thank you very much. So now moving over to greenwashing. Whenever there's a new regulation or law being introduced, clients normally say, so what's my risk? What's my potential sanction? On this topic, it's a little bit different because, of course, the question is, so greenwashing, what does it mean, in fact? When could I end up potentially in the Financial Times because of greenwashing allegations? We have seen that happening. So Lauren, do you want to explain what you understand under greenwashing?
Sure. There's a bit of back and forth about exactly what greenwashing includes, sort of what are the hallmarks of it, how exactly to identify it. But just as sort of a brief definition, it could be considered the deceptive practice that a company or an organization engages in which they falsely convey information that is given the impression that they are more, let's say, environmentally sustainable than perhaps they really are. And key elements of greenwashing that are oftentimes seen but isn't necessarily decisive is misleading claims. So for example, vague or ambiguous claims that give the impression of being more environmentally linked up, let's say. Selective disclosures. So for example, a sort of tokenism of disclosing certain information and not others. Then also particular imagery and branding. So putting green everywhere or leaves or something environmental when really you aren't actually involved in anything of the sort. And then also just a general lack of transparency. So, for example, not having verifiable data or using data that perhaps is somewhat questionable. Sometimes it's not as evident as those items, but at least these are some of the let's say, characteristics of greenwashing.
Yeah, thank you very much. I mean, to add on that, it's, of course, we don't only speak about greenwashing, but in fact also in the funds world, we also speak about green bleaching, because actually what happens if you say, it was mentioned earlier, your Article 6, but actually you do a lot in terms of ESG and you don't provide with the reporting. So I think the risk goes into both directions now. So Ada, moving over to you, so what do you think are the current trends when it comes to greenwashing?
Yeah, so I'll refer to a report for 2024 that was published by the Swiss ESG data and research firm RepRisk, and they have interestingly found that there is globally a cross-sector decrease in greenwashing cases from 2023 to 2024, but correlatively an increase in the severity of cases, and also most companies or many companies that were offenders in terms of greenwashing in 2023 appear to be repeat offenders this year. Another interesting fact that this report has found is that the regulatory scrutiny is really starting to show effect. So in the US, that's mostly due to regulatory enforcement action by the SEC. which is what you see in the Financial Times, as Maren mentioned. And interestingly, for Europe, and especially for the European banking and financial services sector, it's the fact of having more legislation and more regulation around disclosures and sustainability-related claims that is bringing the number of cases down. So I'll add to the vocabulary of greenwashing, green bleaching. The current trend seems to be green hushing. So really companies and institutions being extremely careful around their disclosures and declarations.
Lauren, do you want to add anything?
Sure. Just to build on that as well, there are a number of risks for companies in relation to greenwashing. So this includes, for example, regulatory scrutiny. There's a number of, at the EU level, there are several different legislative, let's say, controls with regard to greenwashing that one needs to keep in mind. A number of these are actually in relation to companies towards consumers. So for example, there is the Unfair Commercial Practices Directive. There's also the Greenwashing Directive. And most recently as well, there's the push towards having the Green Claims Directive. Now, these are primarily in relation to companies to consumers. But there's also, as previously discussed, also CSRD that does also play a role with regard to greenwashing that's more with regard to the reporting and internal of the company itself. There's also the reputational risks as well with regard to greenwashing. So for example, there is the potential loss of consumer trust. There's also the stakeholder relations, which can deteriorate because they may view it as being a detriment to the company's internal ethics standards. And then also, as both Ada and Maren have mentioned as well, there's the media risk as well of having exposure on a larger scale than perhaps would have normally been the case.
Thanks, Lauren. Yeah, and to add a little bit more color, when a company or an institution faces a greenwashing claim, what they're really looking at is a variety of claims that they're exposed to. So those may be claims in tort, but also claims in terms of planning and permitting on projects that they are anticipating. Claims may include human rights violations, claims of fraud and consumer protections, but also securities laws violations. And that's really what the SEC enforcement action is all about. The key drivers underlying those claims are accountability, compensation, so seeking to hold an institution or a company liable for the loss that it has allegedly caused, but also getting it to adhere to policies and procedure and legislation that is climate related. And one really common feature in those claims, especially when it comes to listed companies, is the financial risk. Because invariably what you see if a like claim pops up is quite a drastic decline in the stock price of the company. You often see liability claims targeting individual members of management, including for intentional misleading of markets, investors, consumers, or customers. And then in the end, oftentimes multi-million-dollar fines. And that is something which companies like DWS, but also Bank of New York Mellon, Goldman Sachs have experienced, and which Royal Bank of Canada is currently looking at over a greenwashing claim.
Yeah, so now thinking about what can then companies and stakeholders do as protective measures. Lauren, do you want to start on this one?
Sure. So there are actually a number of best practices that companies and organizations can keep in mind. Some of these actually tie back to CSRD and are based in some of the considerations there as well. But ones that I'd like to highlight include accurate and transparent ESG reporting. So for example, having clear, specific communications, to have data-driven disclosures, to have really an alignment with established standards. Then as well, there's also the third-party verification. So for example, involving independent auditors, and then perhaps as well being involved with either local, national, or international certification programs, which help provide a little bit more, let's say, a stability or at least a sense of security for consumers as well. And then also public disclosure verification, so being very key on what comms go out, what sort of information is presented to the public. Then as well as a more sort of, let's say, internal guide as well, is having regular assessments, and then also involving stakeholders, keeping in mind that there are other parties to be involved, reaching out to shareholders and seeing their concerns as well, and then also having internal trainings and making sure that ESG and sustainability is actually really integrated into the business strategy itself.
Thank you very much. Ada, do you want to add to this?
Yeah, a few words in terms of stakeholders in greenwashing claims. So one very obvious stakeholder are NGOs. I mean, the Luxembourg precedent that we have for greenwashing claim is a case involving Greenpeace Luxembourg versus the Luxembourg Public Pension Fund. Greenpeace previously tried to compel the pension fund to disclose certain documents and information before the administrative courts. And in October last year, they published a statement wherein they very openly accused the Luxembourg Public Pension Fund of greenwashing by virtue of its not emphasizing its investment into 23 of the so-called carbon majors. So those include companies like Shell, BP, Chevron, ExxonMobil. By virtue of its failure to conduct an impact analysis on the environment for about 98% of its portfolio, allegedly. And then lastly, for increasingly investing in companies driving deforestation. Another stakeholder to be taken into account are consumers, and relevant and noteworthy in this context is that we are about to have a framework in Luxembourg for group litigation, respectively, and if you prefer that term, class actions. It's not something we have currently, but there is a draft bill pending which aims at introducing collective recourse procedures, and it will be possible to bring those, including for consumer protection organisms, in case there is a violation of a set of EU directives or their national implementation laws. And among those directives is the one on misleading and comparative advertising, and also on unfair commercial practices, business to consumers. And if you go back to the types of claims that greenwashing entails and which we discussed earlier, you can be sure that within this catalogue of directives, someone will find grounds to bring greenwashing claims on a larger scale. And then lastly, another piece of legislation I'd like to mention in this context is the legislation on the protection of whistleblowers. As you may know, Luxembourg transposed last year the EU directive on the protection of whistleblowers into Luxembourg law. This law has a particularly broad scope in that it protects people signaling any acts or omissions which are illicit or contrary to Luxembourg national law or EU law, irrespective of the sector or the subject matter involved, provided that the information is obtained in a professional context. And this law provides protection to employees, but also to shareholders, directors, contractors, suppliers. So really a broad array of people who could bring claims based on violations they've seen or believed to have seen, including in environmental or sustainability-related matters.
Thank you very much. Yeah, as we have seen, the scope is broad. There's also a lot of measures we can do to protect the companies. But of course, what we also need is that the framework is clear. So that's not in relation to CSRD, but SFRD, SFDR. Now I'm mixing up the term. But SFDR, of course, the requirements are not 100% clear. The scope is very broad. Understanding by different market players is very broad. And then, of course, there are potential greenwashing consequences for non-compliance with some of these regulations, even though there's a big discussion around what are actually the requirements, in fact. And I think this is where we also really need the regulator, lawmakers to introduce clear requirements to protect the market, of course, also of that. So now on that, moving back to CSRD, in fact, and a lot of focus has been placed on the reporting obligations that are created under CSRD. So what are now the consequences for non-compliance? Lauren, do you want to start?
Sure. When you look at greenwashing and CSRD, one of the very interesting things is what actually could be the consequences with regard to a violation or non-compliance with CSRD. Now, CSRD itself doesn't explicitly state exactly what the penalties for non-compliance would be, but instead CSRD, it modifies those let's say, other legislation which relates to reporting and other requirements. So in implementing into their national law, CSRD, countries are then obligated to then further modify their legislation with regard to those particular reporting requirements and also the penalties and sanctions associated with them. Now, that being noted, however, there still is some general sort of, let's say, takeaways with regard to liability and responsibility underneath CSRD. So as a corporate lawyer, one of the key aspects that I look into is the fact the issues surrounding directors' liabilities and duties. When you consider underneath CSRD that directors have the obligation to create the reports or to oversee the creation of the reports, their liability definitely could be on the hook, and it's also related to, or at least similar to, what you see already in the field with regard to directors' liabilities with regard to preparation of, for example, the management report. Then as well, there's also the concern with regard to auditors, because they also have the role of auditing the report, of overseeing it, and their liability also could be incurred as well. In looking at the various different countries that have actually already implemented CSRD, there definitely is a difference between some of the sanctions, some of the penalties associated with it, and then also CSRD opens up the ability for different member states to choose who will be the body to actually look into this. So, for example, the regulator or administrative judicial bodies.
Thank you. We do see quite severe enforcement actions in other jurisdictions. Maybe you want to highlight what is possible under Luxembourg law in terms of enforcement and penalties.
Yeah, I think it's interesting here that we take a look at the draft bill that is pending and that will implement CSRD into Luxembourg law. So to spend a moment on the proposed role of regulatory bodies in monitoring compliance, it's proposed that companies or issuers whose securities are admitted to trading on a regulated market be subject to CSSF supervision as regards compliance with CSRD. And likewise, as Lauren mentioned, there is a whole new auditing field that CSRD is going to create and open up, and the CSSF will also be the authority responsible for overseeing auditors in this sustainability-related audit. And then there is also quite a severe penalty and sanction that is being introduced in the form of criminal sanctions. It will be made clear in the Luxembourg law on commercial companies that there are criminal sanctions upon management if management fails to draw up, to organize an audit of, to file or publish the sustainability-related information, and the same criminal sanctions will be applicable to management bodies of credit institutions and also insurance and reinsurance undertakings, wherever they, as I said, fail to prepare these declarations.
Thank you. And to what extent do you think CSRD is going to operate as a tool against greenwashing?
Yeah, I must admit, I'm not going to reinvent the wheel. I'm going to cross-refer to whereas number 13 of the directive, which is quite explicit and concise, but very informative in this regard. So one aim is to reduce ambiguity through standardized reporting. This is why you have a clear definition of what qualifies as material information under the directive. This is why you have a series of sustainability-related topics that are being identified. And that's also why there is the aim to have comparability in the information that is reported through the ESRS reporting standards that come with CSRD. Then there is also an aim to have increased accountability and accountability of the people that need to disclose per CSRD and reliability of the information that is eventually disclosed. And this is achieved through this set of mandatory disclosures that the directive provides for, but also, and very clearly, through the requirements to have the relevant information audited by an approved auditor.
You want to add anything, Lauren?
Yes, just to add in as well that with regard to all of this, of the framework that's being set out, of the various, let's say, standardization, harmonization, this really creates an enhanced confidence for stakeholders, for example, investors, of knowing that what they're investing in is truly what they're planning on investing in, of being able to have that certainty, that also that what they're looking at would be the same, let's say, standards from Luxembourg to, for example, Germany, to France. That sort of level of standardization, harmonization really creates a certain level of confidence and security that stakeholders, in particular investors, shareholders, can have.
Thank you. And before we wrap up the session, are there any questions in the audience?
What's some of the most common greenwashing tactics Clifford Chance encountered?
Tactics.
Yeah, greenwashing tactics. Greenwashing tactics.
Word.
Yeah, maybe it's easiest if we cross-refer you to some of the cases that have been covered by the media. In the examples that I mentioned that involved certain financial institutions or asset managers more particularly, and please, Maren, correct me, or Lauren, if I explain this in the wrong way, but there was, for some of them, the concern or the finding that whereas they advertised something as being very sustainability-oriented or certain investments to have been made or selected on the basis of sustainability-related criteria, it turned out in the end that they didn't really have any internal policies or procedures that they applied or adhered to select those investments, that sometimes they made the investment and then only afterwards branded it as sustainable or ESG compliant, and even sometimes filled out the relevant questionnaires only after they had selected and engaged in the investment. That is something that can be mentioned, and something which notably the SEC is very, very sensitive to. And then, Lauren, I think you gave some examples of more straightforward misbranding even.
Yeah, exactly. And I wouldn't say that this is from in practice, but at least from looking into the subject online and some research into the subject, the idea of the branding, of perhaps having particular imagery, of bringing forward particular, let's say, small improvements that one has made, but without actually having any sort of, let's say, real impact on the business or the industry. Those types of things as well are forms of greenwashing, or at least examples of what has been seen in the market.
And we have one final question before the coffee break.
Yes, I'm wondering if you could elaborate a little bit more on the risks of civil liability, because I think we spoke a lot about criminal administrative sanctions, but do you think there's actually a high risk of civil liability? Because in the UK, we had Client Earth, I think, on a director's level, which wasn't successful, and at least in Germany on a company level, it's not reporting, but we have RWE in Peru, and yeah.
I think the RVE example is a very good example, but if you transpose that to civil law countries' liability regimes, civil liability regimes, you always have the triple condition that needs to be fulfilled of misconduct, harm that has been effectively sustained, and this harm being in a link of adequate causality with the misconduct. And there you have oftentimes the issue, how do you prove that this environmental damage that was supposedly caused by a company or an institution was directly caused or is only due to those companies, or this institution's actions. So that's a clear challenge that at least this type of claims, if they were to be brought in Luxembourg, which they haven't for the time being, would encounter. And you see that also in Belgian case law, because Belgium has exactly the same civil liability regime. And there, to my knowledge, a lot of cases failed because the three requirements couldn't be clearly established. Yeah.
Thank you, everybody. We have a 15-minute coffee break now, so please thank our panel.